Hello, my name is Adela Kowalski Garza. I'm a practicing attorney for 31 years. I do criminal law. I've taught at the University of Texas, Rio Grande Valley, formerly known as University of Texas in Brownsville. And I am going to talk to you today about the Fourth Amendment. I apologize for the beeping sounds. Apparently some of the alarms need batteries. Okay, let's read the Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So that's the Fourth Amendment. It was implemented in 1791, and it is part of 10 amendments that were included in the United States Constitution. Basically, they were added to the United States Constitution, and it gives the people more protections, it gives the people more rights, and it also limits the authority of the law enforcement to intervene or interfere, or the federal government to intervene or interfere with the lives of the ordinary people that live in the United States. So the Fourth Amendment, as I read it to you, gives people certain rights and privileges, and I will be discussing with you 10 things that I think summarizes and are very important, are highlights of the Fourth Amendment. Number one, the Fourth Amendment, as you said, as I read to you, says that the right of the people, it starts with those words, protects people, not places. So the Fourth Amendment is all about protecting people, not places. What do I mean by that? I mean to say that it doesn't matter where a person is, even if he or she is in a public place, the Fourth Amendment may be applicable. And because, like I said, the Fourth Amendment is about the person, not about the place. That came out very clear in a famous case that I will discuss later, called Katz versus United States. In that case, the United States Supreme Court explained that the Fourth Amendment protects people, not places. In that case, Katz was in a public payphone talking, and his conversations were being listened to by federal agents. The United States Supreme Court explained that Katz had a Fourth Amendment right, even though he was in a public payphone, again, because the Fourth Amendment protects the person, not the place. Now let me give you more examples regarding that. Let's say you are in a public restroom at Stripes, you would have a Fourth Amendment right, even though you are in a public restroom. It's not your restroom, you're not the owner of that restroom, but there are certain protections that the Fourth Amendment gives to you in spite of the fact that you don't own the place where you're at, because the Fourth Amendment is all about protecting the person, not the place. Now, number two, the Fourth Amendment gives these rights, as I mentioned to you, as I read it to you, but it says it protects people from unreasonable searches and seizures. It's not a complete protection from all searches and seizures, just those searches and seizures that are considered unreasonable. That opens a window to a lot of litigation, because what is unreasonable, that's on a case-by-case basis. The courts determine what is a reasonable search and what is an unreasonable search. And I will discuss this later on. But for the record, just remember, the Fourth Amendment does not protect persons from all searches and seizures, only those that are considered unreasonable. And of course, the issue is going to be, what is unreasonable? Now, the Fourth Amendment prefers warrants when it comes to searching a place, searching a house, searching a person, or seizing a person, depriving that person of their liberty and detaining them. The Fourth Amendment prefers that law enforcement obtain a search warrant or obtain an arrest warrant before conducting that intrusion into the life of a person here in the United States. So therefore, even though the Fourth Amendment doesn't specifically say that the law enforcement officer should get a warrant or has to get a warrant, the Supreme Court has stated that in essence, they've interpreted the words of the Fourth Amendment to mean that the Fourth Amendment prefers warrants. And in fact, if there is no warrant, it is per se an unreasonable search. But of course, there are many exceptions. Okay, so warrants are the key. The first thing that a law enforcement officer should do is see if it's possible, if it's reasonable, if it's feasible to get a warrant. Because if not, then potentially that search or seizure could be invalidated. And I'll discuss about the exclusionary rule and what that means later on. The Fourth Amendment is all about probable cause. Before a law enforcement officer is justified in detaining a person, arresting a person, or searching a person, searching his house, searching his belongings, and so forth, that officer should have probable cause. Probable cause is there's no clear definition for probable cause, but it has been defined as a fair probability that in the case of a search, that evidence of a particular crime and particular evidence will be found at a particular place. And in the case of a detention or an arrest, that this particular person, specific person, has committed a specific crime. So the definition of probable cause is a fair probability, but the definition is different depending on what the law enforcement officer wants to do. It's depending if it's a search, the definition is different, and the rules, the applicable rules, are also different. And if the law enforcement wants to detain or arrest, again, the definition is different than for a search, and also the rules applicable for the execution of those warrants are also going to be a little bit, not a little bit, they're going to be different because it's different circumstances. All right, so when it comes to searches, the Fourth Amendment protects a person's reasonable expectation of privacy. What is a reasonable expectation of privacy? In order for the Fourth Amendment to protect you, to protect your privacy, you first have to show that you have a reasonable expectation of privacy. And how do we know? What do the courts say about reasonable expectation of privacy? Well, the Supreme Court has developed a test. It's a two-pronged test. If you pass the first prong, then you go on to the second. If you don't pass the first prong, no need to go on to the second, because then there is no privacy. There's no Fourth Amendment problem. So the first prong is a subjective prong. Did the person claiming that his Fourth Amendment rights were violated by a particular search, did that person actually have a reasonable subjective expectation of privacy? For example, if you go around with a backpack that is transparent, made out of transparent plastic, where you can see everything in it, and you're carrying an open view, marijuana, then you cannot later claim that somebody saw your marijuana and shouldn't have seen it because you had it in open view, and you cannot say that you had a reasonable expectation of privacy. For purposes of the Fourth Amendment regarding searches and the protection against your privacy, I must tell you that at the beginning, when the Fourth Amendment was first implemented, the Fourth Amendment was not really about privacy. The Fourth Amendment protected more the ownership of property of a person. Back in those days, 1791, there was a famous saying that a person's house is sacred. A man's house is his castle, because that's your sanctuary. That's a person's sanctuary. And back in those days, the sanctuary was being violated all the time by law enforcement or soldiers or whatever, going into the house and searching the house or taking over and things like that. So because of that, the Fourth Amendment focused more on ownership, preventing the federal government from interfering with property rights. However, little by little, the Fourth Amendment moved on and changed, and the focus of the Fourth Amendment, thanks to Katz versus United States, moved from property rights to privacy rights. So that's where the reasonable expectation of privacy is very important to the Fourth Amendment, because it protects people, not places. So sometimes in a situation, a person could own a property, but not have a reasonable expectation of privacy in that property that he owns. It depends. For example, if I own a house, and I'm the owner of the house, but I have a party and I invite a lot of people to my house, I've lost some of that expectation of privacy from all those people that are coming into my house. It depends on a case-by-case basis. And in other situations, even if a person is in a public place, they could still have a Fourth Amendment right because they might have a reasonable expectation of privacy, even if they are in a public place. All right, so number 6, regarding seizures. Okay, so the Fourth Amendment protects a person from unreasonable searches, but that depends if the person has a reasonable expectation of privacy. And the reasonable expectation of privacy is a two-pronged test, and forgive me, the first prong was a subjective one, whether that person actually has a reasonable expectation of privacy. And the second prong is an objective one, meaning will society be able to justify or be able to acknowledge the person's expectation of privacy in balancing the person's interest in their expectation of privacy with the society's interest in public safety and the best interest of the country. An example of that would be the borders. When you go outside the United States and you travel onto other countries and you come back from those countries into the United States, you lose your reasonable expectation of privacy because the United States has an interest in making sure that it's protected from whatever it is, from foreigners or whatever coming from another country into the United States. So for example, here at the border in Brownsville, there's people crossing the bridge from Matamoros to Brownsville, and they will be searched because they're coming from another country into the United States. And so the interest of the United States to protect the United States in that balance outweighs the personal privacy interest of the individual. All right, so with regards to searches, since the Fourth Amendment moved on from property rights to privacy rights, conversations, private conversations, or conversations that you have are considered private and are subject to the Fourth Amendment. That is why when the government wants to listen to phone calls made by people, they have to get a search warrant, because under Katz versus United States, a person's conversations are considered protected rights under the Fourth Amendment. And I'll get into that later when we discuss Katz versus United States. The Fourth Amendment applies only to law enforcement. This is number 7. When I say it applies only to law enforcement, what I'm talking about is that the Fourth Amendment is all about intrusion by the government into the lives of the people of the United States. So it's not about private individuals doing stuff. We have the penal code and we have crimes against people for that. But for the Fourth Amendment purposes, it curtails the conduct of the government and limits the conduct of the government so that it won't interfere with the lives of ordinary people in the United States. So when there's a search or a seizure, it's very important to find out who did the search. If it was not law enforcement, then there is no Fourth Amendment problem. However, in certain states, there might be. For example, in the state of Texas, the exclusionary rule, which is a rule that says, and I'll talk about that later, applies to all people, not just law enforcement. So it depends on where the case is at. If it's in federal court, and law enforcement was not the one that did the search, nor did they direct the search, nor did they direct or tell people to search or anything like that, then there's no Fourth Amendment problem. But there might be a problem with the laws in that particular state if the case is handled by the state court and not by the federal court. Now, number 8, the particularity requirement for searches. When I read it to you, the warrants that we talked about here, the warrants, when it comes to search warrants, that warrant has to particularly describe everything, because the Fourth Amendment prohibits general warrants. Therefore, the particularity requirement has to say what particular crime is being investigated. It cannot be, well, I'm going to investigate a crime. I don't know which one yet, but I think that this person's committing some crime because no. It has to be something specific. What particular crime is being investigated? What particular evidence is are you looking for? Where do you think that evidence will be found? Everything has to be specified, and general warrants are not allowed. Now, when we are talking about, and we'll talk about warrants later on, but just remember there is a particularity requirement when it comes to search warrants. The Fourth Amendment has many exceptions. Some of those exceptions we will discuss in this case, and let me just mention some of them. One of them is an investigatory stop, which is called a Terry stop. Another one is a search incident to a lawful custodial arrest. Another one is exigent circumstances. Another one is plain view. Another one is consent. And finally, there's another one called the Carroll Doctrine, which means the searches of a vehicle, and there's numerous others. And we will go and discuss those during my other lectures. But for now, just know that there are many exceptions to the Fourth Amendment requirement because, like I said, the Fourth Amendment is not a complete protection against all searches and seizures. It's a protection against unreasonable searches and seizures. Finally, the exclusionary rule. The exclusionary rule is what gives teeth to the Fourth Amendment. It's what the consequence of violating the Fourth Amendment is that any evidence that is obtained in violation of the Fourth Amendment will be excluded in the trial of the accused. And any evidence derived from illegally obtained evidence or from evidence obtained in violation of the Fourth Amendment will also be excluded. That is what is called fruit of the poisonous tree doctrine. So it's not just evidence that was obtained illegally, but anything else that was later obtained thanks to that illegal evidence, fruit of that evidence, will also be suppressed. I hope this will help you understand a little bit of the Fourth Amendment, and I'll talk about it in more detail in my further lectures. Thank you.